Ladies and gentlemen, this is a great evening. We've got, as I say, a distinguished audience, many lawyers. I'm delighted to see many young people because I think that's very important. And in Benin, we have this series called Talking Art, which usually we're talking to distinguished artists, curators, museum directors, even collectors, David. But tonight we've got a special occasion because we're actually talking for the first time to an attorney, and a very special attorney at that. Howard Spiegler is co-chair of the art group at a very distinguished firm of lawyers in New York called Harry Feinstein. And what we try and do is to try and make the evening a combination of enjoyable but also informative. So if you enjoy yourself, that's great, but more importantly is that you will leave this room, hopefully, with a little bit more knowledge about a very, very difficult and complex subject. Now, it is absolutely impossible in the space of 90 minutes to try and cover with any form of authority the issues involved in spoliation and naturally looted art. It's a bit like asking the Chancellor of the Exchequer to explain the economy within a world context in an hour. But what we can do, I hope, is to try and address specific key points within the process so that you will at least understand some of the different complexities. So the areas that we want to talk about is, I'm going to ask Howard to explain really, first of all, the core definition of spoliation and naturally looted art so that you understand what it means and the context. Then the momentum of why it took to 1998 for the international community to actually recognize formally the problem. After all, 1998 to 1945 is 2 generations. The third element is then what happened between 1998 and the Washington Principles and 2009, which was called the Prague Conference, which is a terrorism declaration. So what I'm trying to explain is that there are not only movements and legal cases which everybody reads about, but there are international protocols and sets of disciplines that governments are supposed to at least follow. Then I want to ask Howard to explain to us the difference between the United States and Europe. And there are very significant differences, both in terms of the legal structures of the countries and how that affects spoliation and looted art. Then I want to talk about the art market itself, because ultimately these paintings either come up for sale and then they're found to be looted, or they are restituted and then end up being sold. So the art market is still a very important point. And then what Howard and you can take your pick, Howard, you can take your pick of any of these famous cases that you represented and explain to us how that mix actually reflects all the different aspects. And then finally, as the point that David touched on, you're at the top of the pyramid. You are absolutely top. You're dealing with all the major cases. But underneath that pyramid, there is a huge volume of innocent parties who simply lost, or their parents lost, or their grandparents lost, and had their apartments stripped of what they consider to be very valuable, but not financially valuable. Valued rather than valuable. And I want to spend a little bit of time exploring that with you. But first, most importantly, is just to get us a little bit more relaxed, I think it's important that you know a little bit about our guests, so I'm going to ask you some very simple questions.
My first real job, I guess, was, after some summer things, was those being the good old days after I graduated from college, and one of my jobs was to avoid being drafted and serving in the Vietnam War, which I, of course, opposed. I ended up teaching in elementary school, 2nd grade and 4th grade, which I thought of at the time as being one big baby teaching little babies, but somehow I got through it, and more importantly, I think they got through it. But that was considered to be a draft deferment, so that was the main motivation for me doing that.
So being a lawyer wasn't, but being a teacher was?
Yeah, it was during that time that I realized that being a lawyer probably would allow me to, what I thought I was going to do was pursue a life of doing pro bono work and public interest work. So I thought being a lawyer was probably a good idea, and I went to law school. Just so you know, I was not an art history major in college, and if someone had said to me at that time, I could look in a crystal ball and see that you're going to be an art lawyer, I very likely would have said, what in the world is an art lawyer? Because there really were no lawyers who were particularly dedicated to that field, and certainly there was nothing along the lines of restitution law at that time.
And your first...
To describe the case, you mean? Sure. You know, before I do that, I did want an opportunity to thank you for inviting me here today, and to thank the good people at LJCC who I've really enjoyed working with, Mandy and Louise and David. Thank you. You know, I've had to deal with a lot of museums around the world who have been mostly resistant in many cases to responding to the claims of our clients and other claimants. Ben-Uri has been in the forefront of publicizing the problem of Holocaust-looted art, and that's been extremely important, as have David and Anne's very important commission in Europe. So I thank you all for, as we say, doing the right thing. Now you want me to tell you about the Dürer paintings case. So very briefly, this museum had been keeping paintings in the Schwarzburg Castle in eastern Germany during the war. American troops arrived, and the next morning when they left, the two Dürer paintings were gone. And then in 1946, an American soldier in uniform appeared on the doorstep of a negligence lawyer who lived in Brooklyn and who was known to collect artwork from the sublime to the ridiculous, and he was shown these two works. Neither of them knew what they were looking at, and he bought them for $400 and put them on his wall, and this was in '46, and they sat there for 20 years, and then in 1966 he was having a party for his art world friends, and a curator of a major museum was on his way to the bathroom, I guess, and walking up the stairs and saw these works and yelled out, "My God, the missing Dürers!" Apparently the whole world, other than this negligence lawyer, had been looking for these works. And he had two choices. He could have decided to quietly take them off the wall and put them in his basement and enjoy them for the rest of his life. He owned the missing Dürer paintings that everyone had been looking at, and he was so pleased to tell this to the whole world. So he was quickly sued by West Germany, which said that pending unification, which of course, as it happened, didn't happen for a long, long time, was really the trustee of everything in Germany. So they were the only ones who could sue on behalf of the German people to recover this painting, which had been owned by a state-owned museum. We represented East Germany, which was not yet recognized by the United States government, so had no standing to sue in the courts, but we kept knocking on the door of the court and saying, there's enough commercial activity going on, East Germany's essentially recognized. The court kept saying no, but somehow the head of the litigation department, Harry Rand, at our firm somehow prevented the case from going anywhere while this happened. And then we were, as I joined the firm, we were recognized, East Germany was recognized, we were allowed in the case. The other claimant was the Grand Duchess of Saxony-Weimar, who claimed that her husband, who was mentally incompetent, had merely loaned the works to the Weimar Museum and therefore was really hers to have. And one by one, first we defeated the claims of the Grand Duchess, and then we defeated the claims of the defendant, and since we were recognized, West Germany dropped out of the case, and lo and behold, the Dürer paintings were returned to East Germany, which I have to say was probably the last thing that the lawyers for the negligence lawyer who owned them advised him could possibly happen. We were before Jacob Mischler, a Jewish judge in Brooklyn, and we're sure that this fellow's lawyers said, there is no way that this judge is going to order that these paintings be returned to East Germany. But he was wrong, and the judge did the right thing, and we won that case, and that was the beginning of this wonderful journey that I've been on. We're talking about works that were seized by the Nazi regime. There were really two kinds of works that the Nazis had in mind when they categorized art. David referred to one category, which was degenerate art. That's how the Nazis characterized works that they deemed to contradict the pure Aryan culture that the German government was at that time trying to promote. And mostly they blamed the artworks on Zionist influences and saw it as another example of the adverse effect that Jews had in Germany. And what were these degenerate works? These were the great Impressionists and Expressionists, Picasso, Egon Schiele, Kandinsky, all the wonderful artists that we have come to know and love, and they ordered that all of these works be seized from the great museums in Germany where they had been exhibited, and indeed Hitler actually set up a traveling exhibition of degenerate art with graffiti written on the walls, and they'd point to a portrait, say, of a woman done in an impressionistic fashion, and it would say, does this look like a woman to you? Isn't this ridiculous? And they made fun of the works. And he invited the German population to come and see these works essentially for the last time. We think that a lot, and it was remarkable number of people came to this traveling exhibition. We think because most were not there because they thought that these were degenerate works, but actually works that they wanted to see because it would be the last time. Luckily for us, although many of these works were destroyed by the Nazi regime, they realized that although they found these works degrading and disgusting, the rest of the world found them to be exquisite. So the Hitler regime proceeded to sell these works at auction. And hence they were dispersed all around the world, making our job and those rest of us who work in this area, making it more difficult to recover. So, getting back to your question, the essential works that we're talking about exfoliated work are works that were seized by the Nazis. But there were also, the Nazis also, in order to, in part, to curry favor in the countries that they invaded, would purchase works from some great museums, but at a woefully low price. So these were really forced sales of works. So the people who were selling them had no choice. They had to sell them, sometimes at pain of death. But this also would be within the category. And over the last several years, there's another category that's now come under this Nazi-looted definition, and that is works sold under duress, not only because they were forced sales, but works where, say, a Jewish family is in Germany, the parents have lost any ability to earn a living because Jews were not allowed to work. The Nuremberg laws were adopted so that Jews were victimized, and anyone who could possibly ponder what was going to happen in Germany and the countries that were invaded, it was safe to say that Jews were in great danger. And many tried to flee. And some had artworks that were of some value. And they would never in a million years have sold these artworks, but for the fact that they needed to earn money to leave. So they would sell them to others. And over the last few years, claims have been brought in the United States and elsewhere to recover where the original owner's family have asked have brought claims to recover these works because they were forced to sell them solely because of the circumstances of the Nazi regime during the 30s and during the war. And some of these cases have been successful. So works that were sold under duress, but not necessarily forced sales, are also part of the definition of looted art.
Okay, just help us to understand the scale. What are we really talking about? Are we talking about 1,000 paintings or 5,000 paintings?
It's really remarkable because having worked in this, really particularly with respect to Nazi looted art for over 15 years, it's still mind-boggling to me. The statistics are really amazing. This was not a mere incident of war, which had happened from time immemorial. Invading armies take the cultural property of the victim country that's being invaded. This was a program designed by Hitler to change the culture of Germany by eliminating the Jewish culture and eliminating artworks that were deemed related to this. It was really part of the final solution, but it was a massive theft on an immense scale. It turns out that the amount of artwork that was looted by the Nazis was equivalent to 20% of all of the art that then existed in Europe. 20% of all the artwork that existed in Europe was looted as part of this Nazi theft. And putting it another way, the US government has estimated that the value of the artwork that was looted by the Nazis was greater than the total value of all of the artwork that existed in the United States at that time. So it was of mind-boggling proportion. It's fair to say it was the greatest theft of cultural property in human history.
And we know that there were cases coming up. You handled one in 1974 in terms of restitution of stolen artwork. But actually, governments didn't actually come together and create an international protocol until 1998. By my arithmetic, 1998 is 53 years after the end of the Second World War. What happened in the intervening period, and why did it take to 1998?
Well, first, the advent of the internet was a tremendous boon to researchers. The idea that you could post images of artworks so that and they could be sent around the world so that millions of people can see them and perhaps recognize works that were once in their family was a tremendous change, and it was a game changer, as we would say. Plus, the Cold War ended. Which meant that not only some archives from the former Soviet Union might become available, but also classified archives in American hands, including military documents, which included documents that reflected the Allies' recovery of many of these artworks as they stormed through Europe and eventually ended the war. So that was a big change. There were many scholarly books written at about the same time, which for the first time analyzed in detail the extent of this program. And that led many journalists in particular countries to start doing more research in this area. And several of our cases actually were in the cultural property area and in the area of Nazi looting were really initiated by journalists who were nosing around and had discovered the facts that they often were in a position to then tell the victims about, which led to other cases. One psychological thing that happened that I think is important to note is that, you know, right after the war, what was left of the families that had actually been victimized by the Holocaust, they mainly had survival on their minds, and they were not about to start looking for property that their family had lost. Many were lucky to be alive, most were not. The next generation who started to ask questions about this were often told, as I'm sure we all have this experience, we don't want to talk about those terrible times. Let's move ahead. Let's look forward to the future. We don't want to dwell on it. But the next generation, which came of age around this time in the 90s, started, seeing photographs of Aunt Yeti's living room in Vienna and said, is that a Picasso on her wall? Whatever happened to that? And they started asking questions and started contacting people who could help them make claims. And so I think the combination of these factors were very important. And in addition, we were privileged to have handled the first major case to recover Nazi looted art in the United States, which started with first New York State and then federal authorities seizing an Egon Schiele painting that was on loan from the Leopold Museum in Austria to the Museum of Modern Art. And the fact that an artwork on loan to a great museum could be seized by governmental authorities sent shockwaves throughout the world. And suddenly people all over the world, including governments and museums, sat up and took notice that there's a problem here.
And that was in the when?
That was that started at the end of 1997, early 1998. And then, of course, the Washington Conference, where, as you mentioned, Stuart Eisenstadt, he was Undersecretary of the Treasury in the Clinton administration, took it upon himself to set up a conference of 44 nations, which was devoted to examining the problem of Nazi looted art. And all these factors contributed to the attention that they gave to this. And they adopted certain principles, which included encouraging claimants to come forward and make their claims, and then encouraging the parties who were in possession of allegedly Nazi looted art to work with the claimants in coming to a satisfactory solution.
And were these protocols actually embossed in law, or were they simply guidance and expectations?
No, there were guidelines, which in some cases, well, in many cases, particularly in Europe, led to many countries looking at this problem, looking at the fact that right after the war, they did not act properly even with respect to works that were returned to them by the Allies, that had been seized by the Nazis and recovered by the Allies and given to these governments to give to the true owners. Many of those did not find their way to the true owners. So these governments, as a result of the adoption of the Washington Principles, set up new commissions in the 90s to look at claims that were made or could have been made after the war, and to allow claimants to come in, not to worry about any statute of limitations or any other bars, and to analyze their claims on the merits. And many claims, including claims where we represented the claimants, were resolved in this fashion. This was a major change. The other thing that happened was that museums all over the world were encouraged, and indeed did, post on their websites, mainly paintings, but sometimes other artworks as well, as to which there was a gap in provenance or ownership history between 1933 and 1945, encouraging people to come forward if you have any information about these works. And that's been really a tremendous, of tremendous importance in at the very least, keeping the world's focus on this problem.
Okay, so let's just hold there for a second. It's understandable, because we all know from our own experiences that those who survived the Holocaust or the children of those who didn't really wanted to keep a distance. It was not a good time, and we know that in many cases it was 30 years plus before people actually started to face these demons and talk about them and realize that there was a new generation that needed to know. So that's perfectly understandable. Equally understandable, perhaps, is the fact that immediately after the war, with all that's going on, for a government to get landed with a crate load or a train load of artworks and to have the duty to try and find the owners who may or may not have survived, well, a little bit of effort, and then the simplest solution is to give them to the National Museum. So that's understandable. And then we go through, and in 1997, after activity, journalist activity, investigative, people asking questions, the Wally case, the Valley case, which was 2 years before, or 1 year before the Washington Principles. I think it's as good enough case as any, particularly following its recent resolution. Why don't you just talk us through that case to actually understand how it started and what were the triggers, what allowed this case to happen,
Okay.
and then take us through.
Okay. So we're talking about a 10-year litigation, so I hope you're prepared to be here for several hours, but I'll try to keep it short. Let me start with the facts of the case. A Jewish art dealer in Vienna named Lea Bondi owned an art gallery, and she dealt with many works, including works by Egon Schiele, a German expressionist painter. And she also, in her private possession, owned one of his works, which is Portrait of Wally. It was a portrait of his lover and favorite model, Wally Neusel. A very haunting portrait, and she owned it in her apartment. In the late 1930s, after the Anschluss, after the annexation of Austria by Germany, Austria adopted laws that took away the right of Jews to have ownership of businesses. Lea Bondi was forced to sell her gallery. It was Aryanized to a Nazi agent named Frederick Welz, and that was it for her gallery. She and her husband were planning to flee Austria in the next few days, and Welz decided to pay a visit to Lea's home in order to, supposedly, to talk about some of the details of the Aryanization. He noticed on the wall, Portrait of Wally. He said, "That's a wonderful painting by Schiele. I'll take that with me now." And she said, "Well, no, you won't. That's my personal property. It has nothing to do with the gallery. It wasn't Aryanized, and that's my work. You can't have it." And by the way, we know what transpired because Lea wrote letters to those who were in a position to try to help her reclaim her property later on. So, and these letters were extremely important, as you can imagine, in the case. So in one of these letters, she said what happened was that her husband at that point said to her, "Give him whatever he wants, quote, you know what he can do." Haunting words at that time in Vienna in 1939, a year after the Anschluss. So she gave him the Wally, and she and her husband indeed escaped and ended up in London a few days later. And she started a gallery in London. In the early 1950s, a Schiele collector named Rudolph Leopold came to her gallery because he heard that she has Schiele paintings, and he was particularly interested in paintings by Egon Schiele. So she said, "You're from Vienna. What happened to my Wally? You should be able to find out what happened." And he said, "Your Wally?" Well, because all the catalog raisonné, all the catalogs in that area always said that Lea Bondi owned this work. It was well known. And he said, "Yes, I know that work. It's at the Belvedere National Gallery, the National Gallery of Austria." She said, "Go to the gallery and ask them for my painting back." He said, "Well, I don't know if I could do that." She said, "Oh, please, you have to do that." And instead, Dr. Leopold, he was an ophthalmologist, Dr. Leopold went to the gallery and asked them if they would exchange the Schiele work that they had for a Schiele work that he had. They said sure, and then he took it and he kept it in his own private possession and never told Lea Bondi anything about it. The way the work had, there's a lot of terrible people involved in these stories. The way that the work ended up at the Belvedere was, which again is an interesting aspect of the case, after the wars, I think I mentioned, when the Allies recovered works that had been looted by the Nazis, they found these enormous number of works in churches, in rubble, on trains, and they made the decision that they would return these works to the governments from which they had come, with the idea that these governments would be responsible for returning them, and they were mainly the Allies. But the United States government had decided that for political reasons, Austria would be considered a victim of Nazism instead of an ally of Germany. And despite the fact that at the time when German troops entered into Austria, they were greeted by almost the whole population of Austria throwing flowers at the tanks to welcome them to Austria. But they were treated as victims of Nazism. So when the Allies found works that had originated from owners in Austria, they did...
Can I just interrupt?
Yeah.
It might just be interesting, because I don't know the answer. Why was that decision made? Why was the decision made to take a country which was so obviously, I mean, after all, Hitler came from Austria, so I mean, there was no contradiction, no doubt.
It was because the government was preventing Austria, and it succeeded in falling behind the Iron Curtain, becoming one of the satellite countries of the Soviet Union, as happened with most of the other countries in Eastern Europe. So that was the plan, and it succeeded. But as a result, these works were given to Austria, and what happened was there was another, I'm sorry, it's an involved story, there was another collector named Rieger, who was also a Sheila collector, and his collection was Aryanized by Frederick Welz as well. Unfortunately, his fate was far worse than Lea Bondi and her husband. He and his wife were sent to Theresienstadt, where they were murdered. And after the war, his children came and made a claim for the works that Welz had taken. And there was a whole list of Sheila works, and they actually had a list, which we've seen. The list included 3 Sheilas, and one of them was a drawing of Sheila's wife. And they couldn't find anything that matched that. But because these are all in Welz's possession, the Wali was mixed in with all of these works that the Allies had seized, and they looked at the list, and the one other work that was there was this portrait of Wali. Now, a drawing is not a painting, and a portrait of one's wife is certainly not a portrait of one's lover and favorite model, but it was interesting because we saw memos from the officers of the U.S. Army writing to the Austrian authorities to whom they were giving these works, and they said, you know, with this one, this Wali doesn't fit. We interviewed Welz, and Welz said, this is not Sheila's wife. So this is not a picture of Sheila's wife. And we don't see this on the list of the Rieger works. So when you look at what to do with this, you should treat this with special attention. As far as we could tell, the Austrian authorities closed their eyes to this, and when the Rieger family sold its works to the Belvedere Gallery, the Wali was mixed in, and the Belvedere, again, we believe they knew full well that there was an error here. They took in the Wali as if it was part of the collection they had purchased, when they actually had not purchased it. So anyway, it ended up in Leopold's ownership. Lea Bondi found out because she saw several years later a catalog of Leopold's works on exhibition, and there was her portrait of Wali. She hired lawyers in Austria to try to write to Leopold and make demands. She never wanted to sue, though, she explained in one of her letters, because she said, if I sue and I lose, which I'm likely to do, a Jewish refugee suing a person who was becoming a major collector of art in Austria, if I sue and I lose, then I'm finished forever. And she was right, because there were many other cases of Jews who tried to get back their works and were not able to do it. So she died without ever having to recover her works. Leopold became a major collector in Austria, and in return for the Austrian government forgiving certain tax debts that he had, they created the Leopold Museum, which was considered to be a private foundation, and Leopold was appointed director of life for director for life of the museum. And then he made a fateful decision, which was he decided to loan these works to the Museum of Modern Art as part of an exhibition, and he included Portrait of Ali in that work. So, as I mentioned, the family was in, many family members were in the United States and in New York. They learned about this work, and they had heard stories from Lea Bondi about this work that had been taken from her. And they went to the Museum of Modern Art and they said, please, when the exhibition is over, don't send this work back to Austria until we resolve our claim. The Museum of Modern Art said we have a contractual obligation to return this work to Austria, and unless you get a court to intervene, we're not going to hold the work here. The family then went to a local prosecutor in Manhattan, Robert Morgenthau, and convinced him to start a criminal investigation into whether or not stolen property had been imported into New York. So pursuant to that investigation, he seized the volley and prevented it from going to Austria. The Museum of Modern Art moved to quash the subpoena, stop the seizure, because there was a law in New York State that said that any works that are loaned for exhibition in a New York State museum cannot be seized. I mean, the idea had nothing to do with Nazi-looted art. It was adopted in the 60s to prevent the creditors of an artist, say, who was showing his or her works on exhibition from interrupting the exhibition and taking all the works to repay some debt. But it was never thought that a criminal investigation by the district attorney would come under this law. But lo and behold, the case wended its way through the New York courts. The highest court in New York ruled that this law, which prevents the seizure of works on exhibition, does apply to the district attorney of New York County, and this work should be allowed to go back to Austria. Meanwhile, anticipating that this might happen, I started visiting in the summer of...
when were your firm appointed?
Yeah, we were retained by the family during the course of the state proceedings, and we anticipated that they might go the wrong way, so I started visiting the federal prosecutors downtown to urge them, if the state court should rule against us, to seize the work pursuant to what we call forfeiture laws, which allow the U.S. government to seize property that's the subject of criminal activity. And the idea was that this was imported into the U.S. in violation of the National Stolen Property Act. And I remember we had several visits with the head of the office that's involved with seizing works that are involved in criminal activity. They had never, ever gotten involved in Nazi-looted art because nobody had. And they were very pleasant, and they took a lot of notes, and I had no idea what they were going to do. And but what we did do was we exchanged our phone numbers because we figured I would find out probably before they would if the state court would rule against us. So lo and behold, the state court decision went down. I started calling all these numbers. I found the head prosecutor at home and said, well, the state court ruled against us. She said, oh my God, I'll call you later, and hung up. So for the next several hours, my client called and said, what are they going to do? Are they going to seize it? It's on its way to Austria. It's probably on a plane. I said, I don't know. And a few hours later, she called to say that the U.S. Customs Service had seized the work and that the U.S. government had started a forfeiture proceeding. And then we worked with the U.S. government, filing briefs jointly for the next 10 years to try to have this work returned to the family of Lea Bondi. Weird things happened during the course of the case. The judge, who later became Attorney General, Mukasey, decided in an early decision to dismiss the case, finding that since the Allies had recovered the volley after the war, it should no longer be considered stolen, so it's not stolen work, so end of story. We urged him to reconsider his decision, which he did, and the case was back on. We deposed Dr. Leopold, and we took his testimony in Austria for a couple of weeks, which is quite interesting. And in the end, a new judge, because Judge Mukasey became Attorney General, a new judge took over the case, and ultimately in 2009 made a decision on all of the major issues in the case except one, and ruled in our favor on all of them. The one issue she left for trial was whether or not, when Leopold brought this work into the United States, whether he knew that it was stolen. He claimed that Lea Bondi didn't tell him why she lost her work. She never told him about Welch, he said. So I had no idea it was stolen. The judge indicated that one would think that when you're dealing with a Jewish refugee who had just escaped from Austria and said that her work was lost, that it wouldn't take much brain power to have concluded that maybe it was looted by the Nazis. But she said, this is just evidence. I want to hear it all, and we'll have a trial. One question was whether Leopold himself would actually come to New York for the trial, because he was too ill to come to New York for his deposition. And indeed, he passed away about a week before, but by that time, we were in, finally, serious negotiations to resolve the case, which we did in the summer of 2010 on the following terms. The Leopold Museum agreed to pay the Bondi family $19 million, which was considered to be the true value of the volley painting at that time. As important to the family were two non-monetary terms which we demanded on their behalf and which the Leopold Museum agreed to. One is that wherever the Leopold Museum shows the volley work, whether it's in Austria or anywhere in the world, it must always affix signage next to it, which explains in detail the true ownership of the painting, Lea Bondi's legacy, and the success of the litigation. And the other non-monetary term was that before it was sent back to Austria, it was exhibited at the Museum of Jewish Heritage in New York, which is a museum dedicated to the memory of the Holocaust, and that was preceded by a ceremony at which Leah's legacy and her ownership were celebrated. And that was done. It was there for 3 weeks, and then it was sent back to Austria. And those non-monetary terms we have found, those terms that whereby the family could feel that the legacy of their ancestor and what they went through during the war is preserved is extremely important. And I should tell you that from the very beginning of the case, when I broached with our clients the possibility that this case might be resolved, or they may offer to resolve it, by the payment of money, they immediately said, we might consider that, but only if these other terms are included. And indeed, they got their wish.
Okay, so we now know that A, these cases could last 10 years, B, it's absolutely detective story stuff. It's just the stuff that movies are made of.
One is that most of the museums in Europe are state-owned. They're owned by the government. So as many European countries have done, including England, they can set up advisory commissions or other agencies that could determine these claims on the merits when the claims are brought against museums. And they have the authority to direct the museums to return the works. In the United States, most museums are privately owned. There could be no governmental authority other than a court that could direct that museums do one thing or another, because the museums are private entities. I think that's That's one difference, which actually would militate toward the greater resolution of these cases abroad, and therefore would eliminate the necessity in many cases of bringing lawsuits, as may be the case in Europe, as opposed to the United States. The other major difference is the difference in the law. In the United States, under American law, one can never get good title to stolen property. So a good faith purchaser of property, having no idea that it was once stolen, if a claim is made by the original owner and the original owner can show that the property was stolen originally, the good faith purchaser has no rights to that property. They don't get compensated for their purchase price or anything like that. They must return it. Now, there are defenses that can be raised, and the statute of limitations is a major hurdle for us in all of our cases. But in Europe, in most European countries, under the civil code, if one purchases property in good faith and holds it in good faith for a certain number of years, which could be a small number, a limited number of years, 3 or 4 years, then they get good title. And if the true owner then comes up after that period of time and says, well, I own that property, it was stolen from me, it's too late, because title, legal title, has already passed to someone else. And indeed, in our cases in the United States, if the current possessor could show that the particular artwork was in Europe at the time, and during that time, under the laws of the country in which the artwork was situated, title had legitimately passed to a purchaser, and then the current possessor bought the property after that, a U.S. court may very well honor that law and say that, well, title already passed, it's no longer stolen, our laws don't apply. But that sometimes courts have found ways around that.
But the starting point, which I think is the real key to this, the starting point in the United States seems to be very different to the starting point, certainly in the UK, where the statute of limitation of clean title is 5 years. Yeah,
the UK, I mean, I'm not an English lawyer. You know, Anglo-Saxon law, of course, all started the same way, but England has tended toward the civil code in some respects.
In the US, let's be absolutely clear, in the US, if something could be proved to be stolen at the time of the revolution, or however many 100 years ago, what you're saying is that the current owner never can have clean title if it can be demonstrated that it was stolen at any point in its history.
Right. What may happen is the claimant may lose the right to sue because of the passage of time.
Yes.
But title, right, title is never deemed to have passed from the true owner.
Okay. So that's one major difference. Then let me ask you another question on this. How is it that an individual can sue another country in the United States?
There was once in international law, before the early 50s, one could never sue a sovereign. The king could do no wrong. And that changed in the early 50s when qualified immunity was recognized as international commerce started to grow. And basically, international law all around the world adopted the principle that you can sue a government if what the government had done was a commercial transaction that really was something that a private person could do. So if the Italian government buys airplanes from Boeing, even for military use, and fails to pay its bill, Boeing was allowed to go to court to get its money back. The fact that it was a sovereign, even using these planes for sovereign purposes, didn't matter. And that made sense under the growing globalization, really, that was developing around the world. And then that was codified in a law in 1976, the Foreign Sovereign Immunities Act, which codified the exceptions to the usual rule where foreign governments cannot be sued. And one of the exceptions that was adopted was if the plaintiff can show that is trying to recover property that was unlawfully expropriated in violation of international law, and it's in the possession of a foreign government, then they have the right to sue the foreign government, as long as certain elements are met, including some important contacts with the United States. So they can't just sue anybody anywhere. But basically that's the basis.
Presumably, because I don't know whether you know, but museums. I mean, one of our museums, income stream, is actually curating exhibitions, and then the term is loaning them to other museums across England or Europe or the world, and that's we do a lot of that. And there is a fee for that. We charge a fee, perfectly natural. But presumably, if we charge a fee, then actually that becomes a commercial transaction.
Well, we had a case. We represent the family of Kazimir Malevich. It doesn't involve Nazi looting, but we brought a case against the city of Amsterdam, which owns the Stedelijk Museum, which had many works that were Malevich's and that we claimed belonged to the family, and we sued in the United States. In the U.S., you can go to the State Department before you're going to have an exhibition of works that are loaned from outside the United States and get certain certifications from the State Department, which if you get them, and they're fairly routinely given, it means that you get immunity from seizures, so that anyone who sues in the United States while this property is on loan cannot get the property. The property has to be able to go back. Interestingly, in the Valley case, this procedure was also in place, but for some reason, the Museum of Modern Art never applied for immunity. If it had, and it had gotten it, and I must say it probably would have gotten it at that time, even the U.S. government could not have seized the works and could not have brought the case, and I wouldn't be here talking to you about this case at all. So it was an interesting mistake that was made at that time.
Before we open it up for questions, I do want to talk about a subject which is very close to our museum's heart, and that is the issue, not at the top of the iceberg, if you like, but the base of the pyramid, the case of families where they've lost works that are simply hugely valuable to them, not in the marketplace, but to them. I think we can understand either cases being, I know that in some cases you work on a contingency basis, so did you work on a contingency basis in the Valley case?
Yeah, it's pretty well known that we did, so yes.
So for 10 years, no income, and if you
Correct.
lost...
Correct. My partners were very unhappy.
but you won, so therefore everybody's happy. But what about the people who simply cannot afford to employ lawyers? There is, I know that the commission to art, which David and chair and run in the UK, is a not-for-profit organisation where they actually will take on cases on that very basis. But that's one organisation. Is there an answer? How can we help these people?
It's a real problem because there's no question that with work that is not of substantial value, even if one could otherwise convince researchers, let alone lawyers, to take on a case on the hope and the expectation that there will be success down the road, and therefore the legal fees and the research fees can be paid at the end. Obviously, with a work of much lower value, that's not a possibility. There are other organizations. There's an organization in New York State called the Holocaust Claims Processing Office, which is similar in the respect that they will take on. Okay, it's not similar. They'll take on any claim by anyone against anyone. They can't litigate. They can't bring a lawsuit. They do research and they try to resolve these claims, and they've been somewhat successful in recovering some work for certain claimants over a long period of time. There is talk, and I've been at several meetings with the State Department about creating a commission, which I think makes a lot of sense, in the United States, funded by the U.S. government, where researchers would be, as I said, paid for by the U.S. government to handle any claims, even of much lower value, to determine the true merits of the case, and then present those to or work with the museum or whoever is possessing the work, and hopefully to work out a resolution of these cases that's reflected by the merits of the case as found by the research that was done. And as I said, this would be government funded, so at least I think a good purpose to be served here would be to handle all those claims where claimants otherwise would have nowhere to turn.
Well, I think it's possible that might happen in the States, simply because we know the United States have a commitment to this. How many European countries in the current state of austerity are going to start to allocate funds for a cause that's already 70, 80 years old? I have to say I have a doubt. But I think it is a serious issue that, because there is a clear dichotomy here. You have at the top of the pyramid those who succeed. Of course, there are many who don't succeed, but we haven't even started to talk about that. But those who succeed then reap a financial reward, which is their due. But those at the bottom of the pyramid simply don't have the means or resources or facilities to actually process their claim and receive back what is ultimately equally as valuable to them in emotional terms as to the Bondi family and the
No question about it.
Okay, but I think what we can do is to open this up to questions now. What I'd like you to do, please, I understand there's a microphone available, and I'd love you to just introduce yourself, and then please direct your questions, please, directly to Howard. Madam, your first hand. Okay.
Can you estimate what percentage more there is to claim in these things?
Yeah, of course, it's hard to tell. I mean, it's guesswork. Those who seem to know most about this have estimated that there are probably around 100,000 artworks that are still unaccounted for, that had been looted by the Nazis and might exist out there, worth billions and billions of dollars.
Sir.
One problem that I've come across is very often antique dealers and private individuals between 1933 and, let's say, 37 or 39, they were desperate to get the painting out or the cash, although cash was subject to 81% tax. So often they went from dealer to dealer, or from private individual to dealer. And I think it's very difficult to judge who actually has the claim. Was it the one who owned it in 1933? Was it one of the other dealers in between? And I think that is a problem. I don't know if you've got much experience of that. I believe also there's a very major new case which is changing German law called the Flesheim case.
Yeah.
I don't know if you want to comment on that.
Yeah, I'm familiar with that to some degree. I mean, we're not involved. I've read about it. Well, the Flechtheims, of course, owned many works that were lost during the war, and usually the party from whom the work was taken, whether it was under duress or looted by the Nazis directly, are the ones we're talking about. If a work was consigned by the true owner to a dealer, the owner still would own the work. So usually you can sort these things out. I mean, I say you could sort these things out. It's immensely difficult to recreate the history involved. But what you're looking for is the party from whom the work was taken unlawfully, but usually by the Nazi regime.
Lady in the second row.
In that Shell case, you didn't mention about the Lauder, Esther Lauder, the son who opposed it and tried to get it taken out of the country, which was a very interesting concept. And also the man who had it owned the gallery, and he was absolutely besotted over show, and he had an enormous collection, and he had to have that particular piece. So there were two important points there.
Well, is the second one you're referring to Leopold? You mean the Leopold Museum? Yeah, yeah.
His whole museum was.
Yeah, well, he clearly had a particular interest in getting this work back. He had a twin, as it's called, that Sheila had painted. It was actually a self-portrait, but it had an interesting similarity to the portrait of Ali. And we think that was one of the reasons why it was so difficult to settle the case for so long, because of this personal, emotional need for Leopold to get his Sheila back. Ronald Lauder was chair of the Museum of Modern Art, but he had also created around this time the Commission for Art Recovery. So people said he's wearing two hats. We represent him and his commission now, and they've done some wonderful work around the world and have successfully recovered many works of art. Frankly, in the Valli case, he played no role. The Museum of Modern Art, although they were very active in the beginning, they dropped out after a while as well. But we never understood that Lauder himself had any personal role, other than trying initially to resolve the case. But as I said, people said he wore two hats, but that was the way it was.
Other questions?
There's one there.
One there? Where?
Oh, yeah, around the corner.
Hello, how are you?
I wonder whether you could comment upon different approaches by different countries. I've been involved in recovering two pictures from a German art collection, one of which was in a small museum in Görlitz in Silesia, and the museum behaved entirely properly and returned the picture. The other was in the Belvedere, who said, well, we bought the painting in 1940, therefore we're entitled to retain it. They returned it in the end.
Yeah.
I just wondered whether this Germans against Austrian approach is something you've met.
Yeah, I mean, we've generally found, I mean, we've had success in at least one case. The Dresden Art Museum readily returned a work that we were claiming on behalf of a family after we showed that it was clearly had been looted. And in general, I think the Germans actually have gotten pretty good marks on this in general. I mean, we had a bad experience with Austria, but it was really, as I said, the Leopold Museum, which, although it's half of its funding, I think, is provided by the Austrian government, half the board is composed of Austrian government officials, was considered to be a private foundation under the laws of Austria. But Austria certainly played a role in the lawsuit, in our lawsuit, and weighed in, not surprisingly, in favor of the Leopold Museum. So our experience with Austria is very, very particular, and it wasn't very favorable as far as they're concerned. But there are other examples. I mean, the Dorotheum auction house, which had a terrible reputation during the war, had new owners as of many years ago, and we've worked with them very well, and they have provenance researchers, and they seem committed to returning work. So I think it may be hard to characterize or stereotype countries. I have to say that in general, we have had more success resolving cases with museums in Europe than we have with museums in the United States. The Leopold Museum tried to argue that the Lea Bondi family had done nothing from the time that Leah had tried to get this work back to the 1990s, when the work happened to appear in the U.S. So it certainly is too late for them to bring that claim now. But as we argued to the court, which the court accepted, was you're just a claimant in this case. The plaintiff is the United States government. They acted in a very timely fashion because they brought the case as soon as you brought your claim to them, and that was the end of it in that case. But that was a very special circumstance. We're embroiled now in a case where we represent the family of Jacques Houdstick, who was a Dutch, Jewish Dutch art dealer, whose whole collection was looted by the Nazis. And we're suing the Norton Simon Museum in Pasadena, California, to recover 2 Cranach works, life-size portraits of Adam and Eve. And the statute of limitations has become a very important issue in the case. The California legislature, and signed by the governor, passed a law that that held that any claims to recover Nazi-looted art shall be deemed timely if they're brought, the law was passed in 2001, if they're brought by 2010, no matter what. And so we sued it. The basis of our suit, as far as timeliness, was that law, because obviously it was tailor-made. And the Norton Simon Museum argued before the courts that that law is unconstitutional because it interferes with the U.S. government's role in deciding about the restitution of artworks, including what the Allies did after the war. So a state legislature can't make its own rules. And remarkably to us, the court agreed. We went up to the Supreme Court to ask them to review the case, and again, remarkably to us, the U.S. government came in and weighed in against us. So the case eventually was sent back to the lower courts to be determined on whatever other statute of limitations laws apply in California. And those laws have been changed since then, and we're now about to argue the case in the appellate court in the U.S. This is very typical for us. I mean, mostly the time spent on these cases is spent arguing that our case is timely. And the statute of limitations varies from one state to another in the United States. So it depends on where the case is pending as to what laws apply, and they do vary. So it's if I become an expert on anything, I become an expert on the statute of limitations.
Sir.
There's a case I read about in the US where some, I think, distant relatives have made some bad and possibly opportunistic claims for art that had been looted by distant relatives, and they were struck out, I think. How do you feel about those cases?
Well, we never take cases like that. Actually, that's true. I mean, we carefully examine, the cases that are brought to us, especially, obviously, if we're taking that on a contingency. The likelihood of victory is not unimportant to us and my firm. But in any event, we don't take on cases that lack merit. And we get calls regularly from people, not surprisingly, who've read about one of our cases in the paper and said, my family had artwork that was looted. And I said, it's good. Do you know where it is now? No, I have no idea. I said, okay. I can refer you to researchers to try to find that out, but there's nothing we can do if you don't know, where they are. Or others have very tenuous claims, or just claims that might have merit if they had more information, but they just don't have enough to bring a case. But there are, much to our chagrin, we have seen, perhaps not surprisingly, that lawyers who have no knowledge of this field have, I think, seen some dollar signs registering when they read about the sometimes enormous sums that are paid for the works that are recovered, and have entered into the field and taken on cases that we wouldn't take. And there are indeed are cases, literally, that we've turned down, and then we see, much to our surprise, that they're being prosecuted, and they usually don't come to a happy end after many, many years of litigation. But it's a problem. It's a problem.
What you all don't know is that there is a very important person at the back of the room who actually dictates this whole evening. Dictates what time we start, what time we start, and is also dictating what time we have to close. So we've got 7 minutes. So I want to use it very wisely. David, I wonder whether you would help us just to give us your view, and I've got no doubt that certain things have been said which you may have a view on. So please, take the floor and give us a professional view as well.
Well, thank you very much. I'll turn around because in the front it's a bit tricky. Well, firstly, thank you. It's been fascinating. I think I just want to maybe clarify a couple of things. Firstly, the overwhelming majority of all the cases are not in the US. You know, I mean, let's be clear. We have the privilege of having Howard here because he's giving us an extraordinary insight into things that we normally just get headlines, actually. And it is fascinating. But the overwhelming majority of cases start in Europe, finish in Europe. Because sadly, that's where the Holocaust happened, and that is where the overwhelming majority of I wouldn't say there are many survivors in the States, but the reality is, and I speak from experience, years of experience, that the overwhelming number of actual claimants come either from Europe or, of course, Israel. So many survivors' descendants have ended up in Israel. And in the overwhelming number of cases, they haven't got two pennies to scratch themselves with. I cannot emphasize too strongly that the overwhelming number of cases are from descendants of families, and David asked the question quite rightly, who really do not have resources, who in many cases, and I have personal knowledge, in many cases, even though they've got no money, do not want compensation. They want the things back. Because many times it represents the only tangible piece of evidence that their families really did exist. Mm-hmm. We're talking of sometimes grandchildren, sometimes great nephews, sometimes second cousins, 3 times removed. I mean, you're not talking here of simple situations. I just wanted to emphasize that. I just want to quickly, because our time is running out, the 98 conference, you're absolutely right. There was the change, the breakup of the Soviet Union, the release of formerly secret papers, generational change. The actual genesis of it, the actual genesis, was the 1997 conference that took place here in London on the gold that was still in the hands of actually Britain, France, and America. And the British government, Robin Cook, who had a bit of a bad press at the time, but in fact it was Robin Cook, when he came into power in 1997, said, yes, because the previous Conservative government, and this, I'm not making a political point, it's a fact, when the Foreign Secretary was Malcolm Rivkin, the Jew, the prominent Jew, would not hold the conference on the residual gold. It's called the Tripartite Gold Conference. Mm-hmm. That conference took, I attended because at that time I was in charge of something and I was at that conference. That dealt with the gold, and the gold was released, and it actually ended up with the claims conference, and the money was distributed to Jews in the former Soviet Union. And it was that conference that decided that there would be another conference in America, in Washington, not only on looted art, but in fact on the failed insurance policies. Because if, sadly, tragically, you died in Auschwitz or Majdanek or Belsen or whatever, you didn't have all the papers to claim your insurance. And there was the conference in Washington which dealt with those two issues, the looted art and the insurance policy. And a great big commission was set up on insurance. It turned out to be highly complex, more complex than anybody realized. It's another story. I want to just emphasize that in the whole issue of looted art, there is a major dividing line between objects that end up in public hands, museums and institutions, and objects which are in private hands, individuals. And when they're in private hands, which is more often actually, you have this enormous issue, it's Solomon's judgment. Who bought and when? Was it good faith? Was it not good faith? What do you do when you find something's in the hands of the child or grandchild of a Gestapo gentleman, which I can tell you we've found in more than one case? What do you do? Who says, well, I've got good title because I just do, you know. The reality is, of course, that once you establish a claim, a family can establish, the European the Commission on Looted Art has this enormous database, the Central Registry database, which is held at Oxford. It's rather like having, it doesn't matter statute of limitations, it's rather like, you know, having a house with no title deeds. You may live there, but you try and sell it, you can't. You can't. Or a car with no logbook, you can't sell it. So there are other issues. But the division of value when something is owned privately, depends how many times it's changed hands. There are people who, in good faith, bought things, because until recent years, Sotheby's and Christie's and all the others did not bother with the whole restitution issue. We haven't touched upon the role of the auction houses, nor indeed all the art dealers, many of whom were Jews, many of whom, who paid not the slightest attention to the whole issue until the mid-90s. I mean, we're talking, as was said, 50 years had gone by. And it's a sad story in that respect. Wildenstein sued and lost when they were accused of this. Mm-hmm. I'm taking too much time. Let me just give you one example of the immense dilemma you get. You mentioned forced sales or sales under duress. You have this extraordinarily complicated situation which comes up more than once, where, it's the question of the rise and fall of values. If a family was forced to sell or sold under duress, but by chance those objects were highly valued in those days, and in 70 or 80 years, actually certain things have dropped in value, and you find, in fact, they were sold forced or under duress, but in fact were sold for more than they probably were today, as well as the other way around. I mean, you get the most extraordinary situations, and it is Solomon's judgment. What do? You get cases where, I'll finish with this point because the chairman will get very cross. One case, obviously nameless, a young man escaped from, I can't remember if it was Germany, I think it was from Germany actually. Family had a bit of money, and he came to Britain, and the family had all sorts of things, and which were looted, and something came up, and they brought a case. In this country and in others, there's a spoliation panel. It doesn't have the force of law, but it has the force of moral authority, which in practice is just as good, because no one goes against it. And other countries have followed the British example. A letter existed, written in 1939, to say, I'm down to my last which was produced as evidence, I'm down to my last £1,000. This was to a member of his family. I'm desperate for money. Things are terrible. You've got to sell something. So we all turned around and said, well, hang on a minute. In 1939, £1,000, you could buy a very, very nice house. Now, where is the equity? I'm not saying I have the answer. I'm just trying to make the point. These are incredibly complex things, quite distinct from the major things that Howard has eloquently described, where something worth $90 million is in a museum, but it might have been worth $900 then. This is the accident of, they call it the economics of taste. So it's a complex issue, and the final thing, how long it will carry on, I don't know. The French go around France and all the museums, and most of the things they've got there came from Belgium and Italy, and they're still there in 1790s. So what do? So the answer is, I'm not sure, but I hope there's been a comment or two.
Well, I think that was asked before. It becomes almost anecdotal. As I said, in general, our experience has been that, ironically or not, the German government has been not that difficult to deal with, at least with respect to the matters that we've had, and in general, their reputation is consistent with that. As I mentioned before, ironically for us, we've had more difficulty trying to resolve claims short of litigation with American museums than we have with European museums in general. So, very general. There are exceptions. I think it's, well, we're working with another law firm and advising them on a case currently pending against the Hungarian government, and we originally represented this family in Hungary, and let us say that one of the claims in the case currently is that the Hungarian government does not have an appropriate set of laws relating to these matters that should be recognized by the United States government, even though in general the United States government, of course, is expected to recognize the laws of any so-called civilized country. So, that's certainly a good example, and we've had our days with Austria, obviously, but it's things have changed a lot over the last several years because the enormous amount of interest that this has fomented, and the work of all of our respective organizations in this field.
Well, you can see, ladies and gentlemen, that if ever there was a complex, complicated, insoluble, unfathomable subject, it's this. And the good news is that we're going to have a 5-minute break, and then we're going to have another 2 hours. I want to thank, if I may, first of all, you for coming. You are the most distinguished audience because you're here, and I hope you've gained some knowledge and greater understanding of the subject. I want to thank our friends at the LJCC for hosting this event. Ben Uri, unfortunately, cannot get 150 people sitting down. Please God, one day we'll be able to get 550 people sitting down, but not yet. And Howard, I want to thank you.
Thank you.
But I do want to just make 2 comments, if I may. One is I can't get out of my head, and haven't been able to get out of my head for the last 6 years that Ben Uri has been involved in this whole subject matter, that this perfectly fair and reasonable pyramid, no complaints about it, but the reality is that the mass of people who have claims can't afford to process them.
No question about it.
And I can't help wondering whether maybe tonight there could be a BU, LJCC, Herrick Feinstein, HF set of principles. And maybe we could promulgate, and you might be able to promulgate, the concept that for those victims who were fortunate enough to employ great lawyers like yourself and other lawyers, may be prepared to take, let's just say, 0.5% from the net gain of this terrible journey, and put it into some form of fund that might be managed independently, that will be able to actually provide the finance just to be able to fund for provenance researchers, for maybe junior lawyers before it gets to the stage of yours. Because otherwise, the United States may well be prepared to fund it, but I can't see any country in Europe being prepared to put money in that direction. And unless it happens, then all that's going to happen is that we will continue to read about the great cases which have been worthy and worthily won. And nobody's going to hear about the mass of people who just don't have a chance of getting back what is rightly theirs. So on that note, I just want to thank everybody, but I have one last thing to do. A little birdie told me that you like poetry.
Did I like poetry?
Poetry.
I do.
You do. Who's your favorite poet?
I don't have any particular favorite.
Okay, well, we have something for you because we think it's only right that we give you, we always try and give our guests on Talking Art a little memento. And we did hear that you love poetry. So on behalf of Ben Uri, we're very happy to give you the complete poems and songs of Rabbi Burns, who's a very famous Jewish
Rabbi Burns.
Might I say happens to come from Scotland, not that I'm so Howard.
Thank you very much. Thank you very much. Thank you. I appreciate it. Thank you.